Immersive Podcast.
Indeed, Immersive Podcast, Dr. Bajada, because this group of people believes in digital capabilities and digital environments, right?
I've always been curious about how law happens as an academic discipline. We work in academia. I don't get it. I don't get how law can be an academic discipline.
And I don't blame you, Dr. Bajada, because it is indeed a unique case in the sense that it's not similar to any other established disciplines. It is not a typical humanity, although it is traditionally classified within humanities, but it also doesn't resemble the more traditional scientific fields like STEM and the such, because our methods and way of approaching problems and most importantly supporting our positions is drastically different. So let me first start by saying that traditionally, if you look at the history of academia overall, law has traditionally been one of the very first disciplines. And I don't think that is a surprise because that has to do with the importance that the phenomenon of the law plays for society. It's not a surprise that people try to systematize their approach to the law early on. And so that's for that part. Now, when it comes to actually how it operates nowadays, it is undisputed that we have our own methods, right? And I will elaborate further.
Before you elaborate, can I just make a slightly or ask you a slightly controversial question, or maybe a statement? I don't know. This is more like a statement rather than a question. To me, if I had to categorize law under any other academic discipline, or at least the academic discipline I see it most closely related to, would be theology.
Yeah, I see why you feel like that. And in certain societies, they have been closely related, so to speak, because indeed, let's say that both disciplines are trying to establish a modus vivendi, way or how we're going to behave, both personally and socially. Of course, as you can imagine, theology has certain other influences that, do not come from the traditional scientific realm. Necessarily, I don't want to underestimate the scientific field of theology. It has come a super long way, but indeed, in the very early stages, it had a certain, let's say, mystifying origin that the law didn't, because the law from the very beginning, it was a social phenomenon controlled by, societies. And indeed, it's right. I mean, you're right to relate it with theology because the further back we go, the more people kinda believe that, you know being able to live in an ordered society was something given to them by the gods or the god or whatever. It was something that allowed them to come out of the state of being a savage, as they used
And
to
you've
call
you've
it.
you've kind of kept the representatives of the gods or of God, but done away with the sort of higher being. So you still have the judge, right, who is acting as
Yes.
representative of God.
Look, the law, of course, has become fully independent from these early days and theological origins. But indeed, there are certain authorities within our discipline, and judges are indeed such
And this is
authorities.
this is exactly what confuses me, right? No other academic discipline has such an authority figure in the same way as law does, right? So academics can be discussing law ad nauseum, and then some judge comes out, has some harebrained idea, makes a judgment that flies completely in the face of anything that anyone ever thought of, and suddenly, there you go. There is an interpretation.
Indeed, and you're right. And that is, partially the tragedy and the beauty at the same time of what we're doing, right? Because indeed, it's not us academics that really get to define how things are being done. And that has to do, nonetheless, Dr. Bayal, with the fact that as a social tool, the law is mostly influenced by established power mechanisms. One of them is the executive, which is the government, right? That has usually takes the initiative in order to produce a law. There is the legislative that makes the law actually happen, and of course the judiciary that makes sure that the law is being implemented. So all three of them are forms of authorities, But I would say that for what we do in academia, court decisions have a more important touch. I mean, nonetheless, that is a little bit my personal take. Not all my colleagues would agree with that. Now, why, how we do that in academia? What is the point of academia, first and
Yeah,
foremost?
what's the point of academic law? Like, if it doesn't fall within any of these, and
Yes,
why?
yes. Let us start from the controversial question that you asked. You said that that academics debate something, then comes a judge and they decide something. That's it. That's not completely true, though. Our job in academia is to assess what the relevant authorities are being doing and to have an opinion, an informed opinion, on whether the outcome that we see is consistent with the principles of the system. And for example, one of our major duties is to annotate judicial decisions. And these annotations are not always positive. I myself, for example, I have many times disagreed with judges on certain issues, with respect, of course, to the particularity and the confines of their role. Because remember that when they judge a case, Dr. Bayada, the fate of actual people depends on what they're going to say, right? Me, as an academic, I have the luxury of sitting at my desk and looking at things from a distance, being a little bit more abstract.
Keyboard activists.
Yes, in a way, but not only activists. I don't like the term activist because it implies a certain bias, and I want to see my discipline as more objective and scientific.
Disimpassioned commentary on society. So in this sense, we are entering the humanities realm.
Yes, indeed, indeed, there is that influence, but we have to be careful because, you know, let's say that the most important contribution that we do as academics in law is that we're trying to rationalize the administration of justice and the legislative process. And in order to be able to do that, there are certain methods and principles that we apply.
Such as
And well, let us, for example, go at the level of the interpretation of the law, right? There are all kinds of mechanisms that we have in order to interpret the law, right? Let's say, for example, that we see a paragraph of the law in front of us. The first tool that we use is the grammatical interpretation, right? We try to see what the language is telling us. That is the first step. But God forbid,
I've heard this phrase before. This is kind of what you say, the black letter law.
this is indeed part of the black letter methodology, but this methodology has more tools than the grammatical interpretation.
Okay.
The grammatical interpretation is only the starting point. And if you ask me personally, I don't think it is the most trustworthy interpretation. Why? Because language can be inaccurate. And many times it does not represent exactly what was that the legislator wanted to achieve. So we have developed further tools in order to be able to decipher that. And we try to do that in as objective terms as possible, right? There are other tools, for example, as the teleology of the law. We're trying to see beyond the language what the legislator was trying to achieve, and maybe we try to see whether the language used was either restrictive or too inclusive. And we're trying to correct the letter of the law by looking at the purpose of the law. There are other tools that we employ. For example, we go down to the legislative history and we go through the legislative process and we see the legislative debate and we try to decipher from that what was the intention of the legislator, so to speak. That is another mechanism that we employ.
Does the intention of the legislator matter? If a legislator intended to write something, or indeed in a contract between people, if we intended something but we wrote something completely different, does the intent is what counts?
Yes, the what we really wanted to achieve is what really matters. Because in law, Dr. Bayada, language is just an instrument. It's just a tool that allows us to express our freedom and our will. So what really matters is our will, not really what the language suggests. Of course, it's clear that a thrifty, clever, smarty pants lawyer would try to take advantage of that and mislead with interpretations that are way beyond what we originally wanted to achieve, of course. And that is part of the day-to-day operations in law, but that is not what academics do, right? Academics usually try to look at what actually was the purpose of the law, and therefore they have an opinion on whether the letter of the law is representative of what it wanted to achieve, and they point that. Many times, for example, we try to warn the judges about such conflicts, and we try to guide them in a direction that we believe is more
Right.
reasonable.
you can imagine that judges are looking at academic outputs in order to guide their sentencing, for example,
They
or
do.
their
They
decisions.
do. They do.
Dr. John, allow me to ask a question that follows up on one of your statements that you just made, and you rightly said that language can be inaccurate, and it is, right? It's a very vague and purposely vague, right? It helps us communicate and
Yes, I can give you a concrete example if you like.
but
Dr. Bajada.
before you give me concrete examples, wouldn't one of the solutions be to have a syntax and semantics that isn't ambiguous or isn't as ambiguous, and so to codify law in, say, computer language, in computer
Yes.
code, perhaps?
Yes. Look now what the irony of it all is, Dr. Bajada. Even the statement that you made, that the law is unambiguous, is already an interpretation. It might be unambiguous to you, but not to
The
me.
law is unambiguous.
Yeah.
I said the law is ambiguous.
No, but you said that we need to frame it in a way that makes it unambiguous, right? And we either use accurate language, you said, or computer code, right? And what I was trying to tell you is that even the conclusion that the legal provision is unambiguous is already a form of interpretation.
Oh, no. But I'm not saying that. So I'm going to correct myself here. I'm not going to say that using unambiguous language or code, which so computer code doesn't allow you to make contradictory statements because it's a series of logical statements. That does not disambiguate the law, but at least it disambiguates the language of the law.
Yeah.
So there can still be problems, but you've gotten rid of a.
Yeah, and I will tell you why. And I'll tell you why. Because even with computer code, there is not 100% guarantees that what we wanted to achieve was expressed in a way that would be unanimously understood by everybody as such.
That's right. I think, in fact, using unambiguous language leads you to sometimes the harsh reality of following through with what you initially stated. And even though, so it happens quite often, right? Where you state something and that seems like a good idea in the short term, but if you follow through with that logic, you end up with something that is either terrible for you or just terrible for everyone.
Indeed, that's another dimension.
Following something to its logical conclusion can often lead to the disastrous results. So in that sense, I think ambiguity is advantageous, but it also then allows for systems that don't mesh well together, they explicitly have interoperability problems because we haven't thought of that. So maybe something from computer programming. So perhaps not using code as law, and I appreciate your resistance to this.
I vehemently resist that.
So I actually think it's a fairly poor idea to do that. Just turn.
I mean, let me elaborate on that, though, Dr. Bajada. Right?
Inspired by programming principles.
Yeah. Look, Dr. Bajada, law and programming can inspire one another because, in an abstract level, they try to achieve similar operations. Okay, code is a form of regulation. It dictates what we can do within a certain predefined environment, and that's what the law does as well. Now, let me elaborate why I vehemently oppose this idea of code as law and such. There are certain situations where automation through code can become very useful. I do not deny that. But remember that code is equally fallible as all the other tools we use to produce law. And the code...
Well, I would disagree with you there. The code is not fallible, right? It's the person who writes the code, right? If someone
You can say the same about language. Language is not fallible, it's the person that expressed themselves. Yeah?
Yes, but someone could have very, very clear intentions, right? And know exactly what they're saying, but in between, the language gets misinterpreted.
And the same can happen with computer codes. A programmer can have clear intentions on what they want to achieve, but they might make a mistake in the code.
But then they've made a mistake. if someone has accurately written the code, it's different from someone has accurately expressed themselves, because even
Why?
accurate expression can be interpreted in many ways. Accurate writing of a computer program can be interpreted in way less ways. It's then logical errors that
Yes,
are the
I
problem.
would be very
And
tempted to agree, Dr. Bayada, but I have an example that was
okay,
already detrimental
give me
than
this
that.
example. I
Yes,
want to hear it, and I want
yes.
to.
No, it is the example of the infamous DAO hack back in 2016, and it all started when a community of blockchain participants wanted to set up to automate the rules under which they're going to invest assets that they collectively put in a wallet, right? Now, the intention was clear what they wanted to do. The thing is, and many people have looked the code again and again and again. The problem is that ultimately somebody was able to understand that while the intention was clear and the code was more or less representing it, there was a slight window that allowed the code to perform actions that were neither intended nor wished, so to speak. And I think that shows that similarly to language, code is also open to interpretation in certain situations. Because in this particular situation, the matter became even more controversial because the person that orchestrated the attack and they were able to take 50 million and put it in their own pocket instead of allowing it to be invested for the common good. The person said, you know something? I didn't do anything wrong. I just executed the code the way the code could be executed. But it is exactly the same thing what we do with language. If you look at a contract, for example, and the language in the contract leaves room for different readings, the person is going to tell you, but why do you accuse me? I'm just trying to implement the contract exactly as it can be implemented. What
Yeah.
is your problem?
But this is done, right?
You know?
If two people have a contract and there's language that is ambiguous, people are going to take advantage of that, and sometimes they're going to be deemed as being correct, and not having not violated this contract because the language is ambiguous and someone has interpreted it in a certain way. The thing is, the ambiguity now is it is it is not, it is slightly different though, because it's not that the language has ambiguity. The code would be perfectly clear, and you will be able to follow the logic as to why it allowed it to. That is just a logical error, right? You can identify the logical error, and there's a difference between logical errors and errors that arise intrinsically from the ambiguities of language. These are
Yes,
different
but
things.
but I still find it to be very close to one another because even with language, you can also say that it is a logical error. The way
You
that
can have
you know
logical errors, and you can have natural inherent ambiguities of the language itself. I do think that the main issue with this idea that code should be the thing that's regulating our lives is exactly this, that we as humans, we find it very, very difficult to see very far into the future the logical downstream consequences of what we've said. So having some ambiguity allows for some safeguards, but this is not ideal, right? This is just saying that we're slightly crap, and
yes.
we need.
Dr. Bayada, you raised that earlier as well, and I wanted to commend. Thank you for bringing it back again. Look, the reality is that the human condition is rigged by risks that we cannot always calculate,
Yeah.
and the best way to navigate the situation is to be able to adapt when necessary. And remember also that the human condition depends a lot on trial and error. There are certain risks that repeat themselves, and we are able to identify them and therefore take mitigation action against it, right? And there are risks that, as you said, we will never be able to predict. And I agree with you that a certain degree of flexibility is always necessary. In fact, I personally, as a legal academic, I really believe on principle-based regulation, on regulation that is based on principles and not on detailed provisions, because, as you said, detailed provisions are meant to fail. It is, in fact, it saddens me to heart to see that the European legislator, for example, in the past decade, has taken a very, very dangerous path of trying to regulate digital environments in tiny bitty details. Right? If you look, for example, at the DSA, if you look at the MICA regulation, the only thing they don't regulate is when the CEO of a company is supposed to go for coffee, because everything else,
given that this is this is the first episode of Immersive Podcasts, right? So we don't know. We have 0 listeners right now, but maybe our listeners come from fields far and beyond the law. So can you go? What is MICA? What is the?
yes, you're right. You're right, Dr. Bajada. I took it for granted. Right. The TSA is a European regulation that is supposed to create a legislative environment for digital applications that we use in our day-to-day lives. That is going to be electronic commerce applications, that is going to be social media, that's going to be content platforms and the such, right?
So
And
just to be clear, it's the EU Digital Services Act.
Yes, it's the EU Digital Services Act indeed. And the MICA regulation that I mentioned is the Markets and Crypto Assets Regulation. So it is a legislative act that tries to put some structure in the otherwise Wild West crypto markets. So, no, yes, sorry. That's another controversial opinion of mine, but I prefer structure in markets. I don't like turbo capitalism, Dr. Bajada.
Really?
Yes, I have certain objections against that. And by the way, that's exactly also why I'm skeptical vis-a-vis this idea that code should rule supreme, because remember that code is being controlled by certain forces that are not transparent. And while...
Okay. What do you mean? How is code controlled by certain forces? This is sort of... I don't understand that. What do you mean? Explain.
I mean that, simply put, people should forget the idea of the noble programmer that tries to program something for the betterment of the lives of us all. Programmers,
but you have instead of people who draft legislations, you could hire a team of programmers to.
That's
to
true,
write
Dr.
code.
Bajada. But first and foremost, the laws that are traditionally produced by procedures that are imperfect, but at least they come with certain guarantees in terms of transparency, accountability, explainability, and the such.
But you
the same
could
cannot be.
Code is explainable, right? I mean, one of the issues maybe is that not everyone can write.
Yes, but remember that you always have to trust somebody who knows programming while you don't.
That is it. But maybe then we need to teach lawyers how to code.
Not only lawyers. Look, in ideal terms, Dr. Bajada, everybody should have been able, but this will never be the case. And look, I'm not saying that the same does not apply to traditional laws. I know that the people that are going to watch this podcast, they don't spend their day-to-day lives thinking about what the government is going to do and the such. But when necessary, when a debate erupts, it's easier to explain them what is going on through the processes that we're currently employing. While the moment the code comes into the scene, there is a certain level of mystification and certain misconceptions. For example, I've noticed many times that people have a tendency to believe that code is objective somehow. That, it is the same way that people think that AI is objective or whatever.
I mean, that's a whole other bag, right? I mean, code can be objective. What you've written. If it's open,
I agree with that. I agree with that.
AI, right? Like these large language models are totally obscure.
Yes.
But actually,
I'm saying that the fact that code is involved, it puts an extra layer of mystification in the entire process, and that makes me always mindful.
But isn't the solution to that to kind of try to, if we as a society believe, which is already dubious, but if we as a society believe that code or programming is an objective way to regulate our lives, but there's a degree of mystification around it, wouldn't the solution be to train society from a very young age in the art of programming, right? So everyone
would be one step. But again, I highly doubt about the success that we're going to have in the levels of code literacy, and there is always going to be people that are more competent than others, which means that we will never have a level playing field, right?
But have you ever tried to read? I mean, you have, clearly. You've read contracts and laws, and I mean, it is almost akin to programming. The language
I agree.
destroyed.
I
It's
agree. I agree. The only thing I'm telling you that makes me a little bit more careful in that regard is that because computers and machines are involved, the people take it for granted that whatever they're being told it needs to be like that because the computer says so. Believe me, if people would believe me as a lawyer in the same religious manner, I would have been a happy man because the exact opposite is usually the case, right? Whatever lawyer says, the people will immediately object and will say, no, 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 it's not that. No, no, no. You just want to make your fee larger or whatever. But look, I understand that there are many similarities. What I'm trying to tell is that we have to acknowledge, if we want to go down that path, that there is going to be inequality, and then we'll have to address this inequality not only through literacy, but in certain situations we might have to take other measures as well. You know,
but there's already inequality. So what measures are we taking right now?
Well, that is also an important issue. I agree with you. Again, if we stick to digital environments, there is huge inequality, right? There is the average user in the platform, for example, and there is not much that elevates the position of the average user without the law, right? This is why, for example, we have all this network of regulations coming from the EU. They try to empower, as we like to say. I hate that phrase because it says too much and nothing at the same time. But in any case, it tries to improve the position of the average user. It allows the user to retain a certain degree of control over what is happening with digital assets, digital environments, and the such.
Okay, I have a comment on this, and we're veering from what we were originally talking about, but that's fine.
Yeah, that was inevitable.
Yes, yes. This slide. So I agree with you that the EU tends to take the stance of empowering or enabling the user of whatever in the tech sphere. But once a user wants to sort of take the plunge, let's say, and start profiting out of the system, it is a really harsh and difficult transition, I think.
I agree.
So we are going to
I agree.
experience this right now, right? We've previously been consuming podcasts, and now we're going to be creating
Yes,
podcasts.
true.
And it is a very unintuitive leap, and it seems like the law doesn't, at least you're sort of thrown into the deep end.
Yes, I agree, Dr. Bajada, and that is something that I want to make clear. And that is part of what I understood as a legal academic, right?
Yeah.
We have to understand that the law is a tool that tries to achieve some kind of social balance so that a society is functional. Now, this balance is not always ideal, right? And this balance is, how the balance is going to be formulated is controlled, unfortunately, by power as well. Sometimes the law only reflects a certain power relationship and the such. So I would agree with you that it's not always the most decisive or the most effective tool. But believe it or not, it's the best we have in our hands because remove, for example, EU digital law, and we would live in a digital utopia already. It is already bad, but it would have been a trillion times worse. Now, why the law is not as effective? Why? For the average user. The average user would have been, the average user is already in a very bad position. I'm not saying that, but believe me when I say that average internet users should feel thankful if they happen to live in Europe and not in the United States.
Tell me why. Is it the barrage of cookie banners?
Not only cookie banners. The thing is that in the United States, the state of turbo American capitalism right now has reached the phase where average internet users are products for exploitation, and there are no limits to that exploitation.
Can you explain?
It's only the fact that the personal data is being harvested mercilessly without any limitation.
There was the breach recently, right? There was this mega breach.
Yes. But it is the entire system in the United States where it allows digital platforms to do whatever they want with their users, the user's data, or even the user's content, without the user being able to do much. To give you another example, Dr. Bajada, in the United States, users are usually forced to go to arbitration instead of having access to a court. Now, people might say, well, why not, right? Arbitration is faster than the such. But I can tell you something for a fact. An arbitrator is a private company. And a private company makes money, and the private company makes more money from the platform, not from you, which means that arbitrators that sit in these cases are definitely biased. I can tell you for a fact that, if Google, for example, takes 300 arbitration cases to an arbitrator, he will be prone to decide in favor of Google because they bring him the money. It's not Dr. Bayat or Dr. John that bring the money. Arbitrator wants to make money, doesn't really want to make justice. We have state courts for that. This is why I insist so much on, not allowing people to lose that. And even worse, Dr. Bayada, in the United States, it's a step further. Not only they go to arbitrators, now they have completely digitized that. They have digital platforms as arbitrators, which is even worse. I mean, in my early days, when I was writing my PhD dissertation, which is exactly on how average users can have access to a court in digital disputes, I was shocked to see that internet platforms were trying to cultivate a culture that was telling their users, you know something, you don't need the courts. Why do you have to lose all the time and money? We have a platform. You can submit your request and we're going to take care of everything. It's just another service.
I understand your pain. One thing, though, that sort of bothers me slightly about sort of pushing everything to the courts, and this is maybe my experience and sort of what I see, is the courts tend to be incredibly inefficient, and
I agree
also
with you.
is extremely expensive. So
I agree with you.
How do you balance sort of the...
I agree with you.
Yeah.
I mean, let us first start with how expensive courts are. Of course, really depends on which country you live in, right? If you live in Greece and Malta, they're relatively cheap, and you can have relatively, but they are horribly inefficient. And I will agree with you on that.
They are inefficient and they are relatively cheap, but they are not free, and
For sure, they are not. They're not free.
Associated with them, right?
Yes. What my concern is, Dr. Bayada, is that I do not question the fact that arbitration or alternative dispute resolution, digital alternative dispute resolution methods can be effective. And they might also make justice. But my concern is that what I want to make sure is that if an average user is not satisfied from the outcome of such a process, that they can always go to state court.
When would they ever be satisfied, though? Like,
yes, they will. There are situations that they are satisfied.
Situations where something is agreed against you, you have lost this case, whatever the case may be, and you come out of that situation saying, "Oh yeah, I'm really happy with that."
Yes. Because remember that there are. Let me clarify. Remember that there are different types of average users, right? There is the commercial average user. These are people that want speed and efficiency. So if they go to an arbitration, they lose, they will accept it because that's how they do it, right? That's their modus operandi.
Right.
And then there is the everyday layman like you and me, Dr. Bayada and Dr. John. Now, you're right to be, thinking that we might always want to take it to a state court just for the sake of taking it, because we will never be completely satisfied with an arbitration. And you might be right on that. But the reason why I want to defend that is that, remember that in many of these disputes, what is really at stake is your fundamental rights. It's not really about the money or whatever. Many times, and I don't want...
If it's about the money, it's also crippling, right? If you're financially crippled.
I agree with that. But still, I still want people to have an ultimate opportunity to go to a state court. Because... again, you might say that this might create a never-ending circle of, disputes and such, but that is the risk of the platform. If the platform doesn't want to go to the court first and wants to go through arbitration, they must assume the risk of going through an arbitration and having to go to the court again. Because
I suppose that situation is in all ways in favor of the user, right? Because if it's agreed in favor of the user is not gonna...
Exactly. The user is going to go to court. They might say, okay, we'll let it here. But again, you see me being so sensitive because I want people to understand that even in the most trivial, let's say €2 dispute with a platform, it is their fundamental rights that is at stake. You had a €3 dispute once. I remember, Dr. Bayada.
I was riled up.
Because we discussed back in the day, it was not the €3 that you cared about.
It was not the €3.
It was the fact that the platform was removing your freedom.
Just infuriating. Yeah.
Yes. And and although in your case it was your inability to watch a movie and it might seem trivial,
Yeah.
the devil always lies in these trivial details.
Yeah.
Because the moment people start saying, well, this doesn't matter and the other doesn't matter, it's a slippery slope. It ends up in a situation where people stop caring. And look, again, as you have pointed, and I agree, even for people that do care, navigating through the rules and the court and such, it's still difficult, but necessary. I agree with you that we have to work in making it more efficient. Absolutely. We have to lower the fees. We need to improve speed. We need to train our judges in order to be able to understand these issues better. Because, Dr. Bugada, you might be shocked, but judges still struggle with, navigating digital environments. I don't want to blame them. It's not an accusation. I myself still struggle, and I am a legal academic in IT law. But the system needs, to be improved. That's for sure.
So why not another controversial question, coming back to your point that laws need to be principle-based, right? And principle-based legislation is very difficult to do, I understand, with code, because code is very specific and you end up specifying all sorts of details,
Indeed.
right? But recently there's been a boom in artificial intelligence, right?
Mhm.
And so we could leverage AI models, so large language models that can understand context and principles to either legislate or to interpret. And what are your thoughts on that?
Look, I personally don't have any tech phobic feelings. I believe that technology could take us, a certain way. What I am really my main concern here is that nonetheless we need to understand the limits of what these machines can do and deploy them only in a way that is meaningful and useful. So I'm not saying to throw them out of the window for sure, but I wouldn't let them be the ultimate judge, jury, and executioner of such matters. Human control, supervision, double checking, and everything will still be necessary. And again, I don't question the capabilities of the machines and the sats, although I also don't want to exaggerate them, because I have a feeling that the market right now glorifies what is otherwise a parrot. But
It is no, it is definitely not a parrot.
well,
But I do think there is some overhype, at least
know,
at the current stage.
I will stand by the parrot.
0 to GPT-4 in what? How long has it been? It's been crazy, right? The progress has been completely
Yeah,
banana.
but still, Dr. Bayada, this is why I said parrot. Without you at the helm, it can do nothing.
As yet.
Yeah,
And
but that's the problem with these things, though, right? We diverge a bit now, but that's the problem with these things. The vague promise of these things being completely autonomous already makes people
not
give up.
entirely sure it's a promise, and it sounds more like a threat to me that they'd be completely
Yeah, it really depends on how you want to look at it. I say promise, put it so to say politely, but in any case, in order not to go to this discussion, because I believe that can be another immersive podcasting discussion. I want to go back to your original point, and I say yes, AI tools can be used in order to, to certain parts of this process, but always with clear understanding of their limitations and humans at the helm.
Yeah, and also with their limitations is I suppose the data they ingest, right? I mean, if
Yes.
what is acceptable to input into these models, especially if
Let me put it in these terms, Dr. Bayada.
will be used to train future models.
Let me put it in these terms, Dr. Bayada. And I come from a legal tradition, and that is something that probably our listeners need to know. I have been trained in Greece, right, in law. So I come from a certain social background that carries certain ideas. In my understanding, Dr. Bayada, justice cannot be modeled after statistics, right? That can help us, that can show us tendencies and the such. But remember that each individual case, each single case, it's so unique that it's very difficult to fit it within statistical models or whatever. So, while these machines can give you a tendency, the ultimate power should rest with the human judge or the human legislator that has the responsibility to decide what is justice in a specific situation. And it can be very specific. I can tell you, Dr. Bayada, that
What is
you
the
can
difference?
have.
What is the difference between a judge learning statistics about the world and a machine learning statistics about the world? Because that's effectively what's happening when we're learning, right? We're learning statistical
You're right. What
about
I
the
was
world.
trying to say, you're right. It's true that judges, after the many very years of experience that they have, let's say, an internal statistics model. They know how things play out. But that's what I was trying to tell you, that
Yeah.
even they
Mm.
might go outside of norms and models in each individual case.
Yeah,
Why?
of course.
Because as I told you, justice is always dependent on the very delicate details of each individual case that can never be replicated 100%.
I mean, listen, this is where I start disagreeing with you. Okay. So judges can get dementia, and no one knows about that, right? So early cases of dementia, someone's having a neurodegenerative condition, they are making really poor decisions. Their internal framework, their the scaffold that is sort of their computing power is decreasing drastically, and we don't know about it. AI models do not get dementia. I mean, I suppose they can have
I
some
agree.
similar process.
I agree. I agree on the general observation. But remember, Dr. Bayada, when we say you go to a judge, you don't never go to a single judge, right? The system has methods of appeal and other ways of, if such a mistake happens, as you said, it can be corrected, right? So I would say that, in
You could use different models, right? I am, or you could have like an some sort of AI system to be the lower court, where the initial
do that.
process.
You can do that. Of course, again, I would still insist that a human is still the ultimate.
At this point, I don't think there's any other way to do
You
it,
know,
because sometimes the outcomes
Um,
are complete. Not
but yeah, you're right that these machines don't have certain human limitations. They have their own limitations nonetheless. And again, I'm telling you,
and this is
from
this, but they also have their efficiencies, and this is the point where I'm getting to. That if anyone who knows, at least in any system that I've ever experienced and spoken to anyone, no one's ever told me, oh, our legal system, our court system, it's great, it's super efficient. I have
no, it's
a
not.
I have a
It's
problem,
not.
and within 2 to 3
It's not.
weeks it's solved. It is not.
No,
It is.
2 to 3 weeks is never going to happen. I can tell you that where I come from, you're going to need up to 30 years, even for
Right.
trivial cases. And of course, but let me make a disclaimer though, right? That's because my country of origin has completely failed at that level, right? My country of origin being Greece. Greece is the worst example of administration of justice in the entire EU, only bested by Italy, for what matters, right? If in Greece you need 30 years, in Italy you might need up to 40.
I am not
But
even
that's
gonna go
because
in anything about Malta's.
Malta is coming along nicely, but still a little bit faster than these two. But really, Dr. Bagata, you're right. Of course, I agree with you that within a system with so many inefficiencies, I see why such tools look very appealing, and I don't disagree. What I'm saying is we just need to be aware of their limitations and make meaningful use of them, not give up, so to speak, any authority or whatever, because it's impossible. And I personally am a little bit cautious. I don't think that there is going to be a point where we can completely relinquish control or anything. But in any case, that is up for debate, and both views are equally
You
valid.
don't believe in the singularity.
I don't believe in the singularity, Dr. Bayad. I'm sorry. I'm an infidel. I look, let me put it in these terms. I like science fiction, but I know its limitations. Science fiction is science fiction. And it will always be science fiction.
We're gonna get back next month. The singularity has happened, and you're gonna apologize, right?
Okay, yeah, try to make me apologize. I would welcome. That is, by the way, part of the scientific process, Dr. Bayada, right? That is the beauty of science, even in law, that we have the honesty and courage to admit that we are wrong if somebody can prove to us that we were wrong. I think that is the very beauty of the whole ordeal.
I see. So you, in your view, there is an element of science in the academic
Yes, there
discipline
is.
of
There is. There is.
law.
Look, I struggle myself many times, Dr. Bayada. I would have wished that my discipline is a little bit more objective than it currently is. But I know, on the other hand, that because law is a social tool, this is impossible. What I want to,
Behavioral economics, all of those are sort of taking scientific
yeah,
principles.
you can always employ these things, but at the end of the day, Dr. Bayada, what we cannot do at law is completely rid ourselves of biases or our own personal
But
limitations.
I
It's
don't
one of
think you
us,
rid
you know.
yourself of biases completely. I mean, our biases are kind of ingrained into us, right?
I
we can
know,
build.
but then look what the problem is, though, Dr. Bayada. Because in law, look what the problem is, though, Dr. Bayada. In law, as a discipline, we don't have a method by virtue of which I can say that something that you suggest about the law is completely wrong, and something that I suggest is completely right. We don't benefit from this level of certainty that other sciences might be able to achieve through mathematics and forms of experimentation and the such.
But
Uh,
you can be embedded in sort of for example, human behavior. There is a sort of an element of statistical certainty. You're not going to have.
Look, I agree with you. I agree with you that our opinions, I agree with you that our opinions on how to interpret the law can be informed by relatively scientific methods. I agree with that. And we can employ all kinds of different tools from all kinds of different sciences.
And you
But
can
I can tell you something bitter about my discipline, Dr. Bayada. Our ultimate limitation is that, remember, that how the law actually happens, again, it really depends by power institutions. And at the end of the day, it ends up being like a popularity contest. Let's say the opinions will prevail that happen to serve certain power structures better, no matter how badly argued they are, or no matter how unscientific they are. And that is
Mhm.
something that we will always suffer from in our discipline. There is nothing we can always, but and because you asked me, this is part of our duty as legal academics, that we are there to point such situations. We are there to say that, look, what the court said, what the government did, or what certain people propagate is wrong for this and that reason. That's as far as we can go. Because as I told you, it ends up being a popularity contest. I can tell you, for example, Dr. Boyata, that I myself, I'm an obscure IT law academic. The chances of me winning such popularity contests are minimal. But you might say, then why do you keep trying? Because scripta manent. Maybe one day some of the ideas that I expressed might prove to be useful to somebody. That is all I can hope for, nonetheless.
Okay, I think we've reached a natural sort of endpoint to our first immersive podcast session. I think that was a beautiful statement at the end there, Dr. John.
What? That
Uh,
I'm an obscure academic?
okay, so we're gonna try to do these every month, and we're gonna see how they go.
Indeed, Dr. Bayada, indeed. And because we didn't introduce that in the beginning, we might want to say a few words now.
No,
Uh,
no, no.
no, let it be. Let it be.